All right, this is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for July 19, 2022. Again, all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
In cause number 2021-0D00202, State of Texas versus Jagger Glenn Walking Eagle. Announcement of council, please.
King for the state of Texas.
Good morning, Your Honor. Jose Montes for Jaeger Walking Eagle.
Good morning. And final judges conference. Ms. King, what's the rec in this case?
It's going to be 15 years TDC as well.
Mr. Montes, I understand. I think we've always been at trial. I know Mr. Lozano was here on his client earlier. He had to go, but we're set for August. Anything outstanding?
Your Honor, I think I don't know what Mr. Lozano represented, but he was waiting for some records from South Dakota. So that's been part of the delay, which are relevant to the defense.
So he did mention something about some type of packet that was outstanding. We're kind of on a tight timetable, so I'm going to leave the settings as is, but I am going to ask attorneys that, please expedite to the best that you can to the state any information that you have that might change that rec. The state mentioned that they had out-of-town witnesses, and so I'm not resetting. I just know if we get to the point where we're still at a trial, because I want to make sure you all are basically specially set, we may change the date. For now, I'm going to keep the settings, okay?
Judge, I reached out to Mr. Lozano and I was told that he had COVID and he was working from home.
Yes, he was. He logged in remotely. So that's kind of why we didn't wait, because
Okay, Judge.
He didn't
I'll
look
go ahead and communicate with him and we'll try and get ready. If not, we'll let you know.
Okay, thank you very much.
Thank you, Judge. Have a great day.
Take care. And I also see Mr. Anchondo. Let's take care of Nunez. I'll go ahead and call him. Mr. Anchondo, are you there?
Yes, Judge.
Okay, perfect. Calling 2021-0D0-2706 and 2020-0D0-2897, State of Texas versus Pedro Nunez. May I have announcements, please?
King for the state of Texas.
Christopher Anchoma on behalf of Mr. Nunez, Judge.
Good morning. We are here. We're set for trial on Friday, but I thought this was always not always going to be a plea, but it's turned into a plea.
It's a plea, Judge. I have the plea documents. I went to get them signed. I need to just turn them into the court and get it set for a plea.
Okay. Let me see. He signed them already?
Yes, he signed them. I have them in my possession at the office. I just haven't had a chance to scan them and send them over to the court.
Well, how about this? What if we do it on Thursday in person? Are you available at 11 a.m.?
Oh.
That sounded painful.
It's because I'm doing all these in-persons and Zooms back and forth. Like right now, I was doing it in person. That's why I'm late. At what time, Judge?
I'd say 11, but we're pretty flexible. So
11 works. I have a 10:30, but that'll be done quick.
We'll take care of you whenever you get here. But let's arrange. We need to have Mr. Nunez brought over on Thursday. If you want to hold on to that paperwork.
Yeah, I can hold on to it.
Yeah, and I'll just sign them once we're here. We'll do it old-fashioned way. Okay.
Sounds good. All right, Judge.
We'll see you at 11 on Thursday. Thank you.
Thank you. Oh, Ms. King, real quick, Judge.
Yes.
On this one, you had sent me the plea documents on the 2020 case as well, but I was under the understanding that case was going to be dismissed because of the non-pros that we had tendered.
Oh, for the injury to a child?
Yeah, it's an elderly.
Or elderly, let me see.
That's an important point.
Yes.
Give me 1 second. 2020. I don't see the non-pros.
I will send it over to you again.
Okay, just send it over, and then I will honor that. I do remember that discussion with ADA Flores as well. I think I was waiting for the non-pros.
Okay, I'll send it over to you today.
Okay, sounds good.
Thanks, folks. We'll see you on Thursday. Thank you very much.
Happy to see you.
Absolutely.
Thank you.
Okay, are we down then to Mr. Dakotes?
Yes, Judge.
Okay, let's go.
In cause number 2021-0D02881, State of Texas versus Luis Puente Garcia. Announcement of council, please.
Raul King for the state of Texas.
Morning, Your Honor. Matthew DeCote for the defense. Ready, Your Honor.
Good morning, and just there is a notation. Mr. Puente Garcia, I think we had agreed at the last hearing to waive his presence for today. I know at least for my purposes, I was thinking of his health and having him moving around so much, but it was just a continuation of our motion to dismiss hearing. I don't recall, I don't think I've received any additional information on the motion to dismiss. Did Mr. Dakotes, did you have anything else for the court?
I just have argument, Your Honor. I did receive another supplement from the state this morning. I read over it. I'll address that when the court's ready.
Let me pull that up. My apologies. Let me see. A lot of filings yesterday. Let's see. Okay, so Ms. King, I'm going to ask you to go ahead and I'm just seeing this now. So please tell me about your supplemental brief.
Yes, Your Honor. So for our last hearing, I know the request was for the medical records. When myself and the investigator got a hold of the TDC, they requested that we actually go through the usual process of requesting medical records, and we have already done that. We have actually also requested the transportation records, but they needed a subpoena, which we have already issued, and we still have not received anything. And Your Honor, at this point, after reviewing the defense's motion, the only argument that I actually add in my response is the Woods case, where, the defense is pretty much using the motion to dismiss as a pretrial motion as a vehicle to prove an element of the offense. And the element here we have is notice. So that's the only additional argument in the response that I filed actually this morning. And we did receive, it is an exhibit that I have added, the only new exhibit, which is the fastest thing I can possibly receive from TDC, which was the day the defendant was actually transferred to TDC and when he was released or discharged.
Mhm.
I know the court was kind of requesting that last time, but that's the fastest document I was able to receive.
Mhm. Mhm. Yeah, so for me, I don't know that clarifies what I recall to be the issue, which is that the defendant was receiving medical treatment, I believe, in Houston at the time, because I think this supplement says that defendants, I'm sorry?
I think it was Galveston, pardon.
Galveston. Mhm. Defendant's motion to dismiss should be denied because the defendant was properly served on March 12th. That is the issue, is again, the notice. All right, Mr. Dakotes.
Thank you, Your Honor. A few suggestions. One, the state, obviously, the prosecution works to see that justice is done. Number two, that's under 201 and 202 of the Code of Criminal Procedure. Number two, as to the nature of the evidence as it is, if we did try the case, I'm not sure under the nature of the evidence as it is that the state's evidence would survive a directed verdict or motion for acquittal based on that notation that the defendant did not get notice. I didn't know that until the prosecution put on their evidence. So it's not my evidence that shows that, it's the prosecution's evidence.
Mhm.
And then our suggestion was that we basically used the entrapment defense 806 of the penal code, suggesting that as a matter of law, we've established entrapment primarily because the state sought the protective order. Our contention is our client never got notice of it. And then now that the state knows that, or at least I think they do, they're still proceeding against him. And we would suggest that's entrapment. Now, I have a little blurb here on entrapment as a matter of law, and it's hardly ever used as a vehicle. I don't think most practitioners even know it can be used as a matter of law. But the only way I can win a motion for pretrial judicial determination of entrapment as a matter of law is if I establish it. I have to establish it since it's an affirmative defense beyond a reasonable doubt. And I would agree with the state that if the court believes there's a fact issue, that number one, if the court believes there's a fact issue, then I can't establish it as a matter of law. And number two, if there's a fact issue, I admit that both sides are entitled to a jury trial on that. But my suggestion to the state, based on all the circumstances of this case, is to seriously think about dismissal, because I don't think that he ever got notice. I mean, that's what I think. Now, if we're just arguing because the state's on one side and I'm on the other side, and if we're just arguing because of that, well, that's one thing. I mean, I understand that. But if we're arguing in the interest of justice, I don't know. I'm not so sure about this case. Thank you, Your Honor.
Thank you, Mr. Dacotes. Do you have anything else, Ms. King?
Your Honor, well, it seems that there are factual issues, and that is for the jury to decide. And we have requested the medical records and we do have a jury trial date set. So.
When did you, excuse me, when do you anticipate receiving these additional records?
Your Honor, we requested it approximately 2 weeks ago. It's with all transparency with the court, I am not 100% sure. I can say a month, I can be totally wrong. I know they seems very hard to kind of, I guess, work with TDC. When I spoke to my investigator, it's just the regular subpoena to receive those medical records. And I actually also requested the transportation records. We usually receive those on very fast track. I believe it's been a month that we usually receive these records. I'm not 100% sure, Your Honor.
Okay.
I can keep the court appraised of any updates I receive. I'm more than happy to do that.
Okay. So the attorneys are, I mean, I think I've said this at previous hearings. My issue is, obviously we have a family court protective order that says that he was provided notice of the hearing in which the default protective order was entered. And as Mr. Dacotes referenced, the exhibits provided by the state had some notations that indicated that he was not. And I'm not sure that it's something the family court would have been privy to while they were doing that. But we have what is, at least on its face, a valid protective order that is in question. So I do think the reference medical transport records are useful here. And so we have a pretrial 2801 hearing set for July 28th. I just mentioned that, Mr. Dacotes, because that's really where I am. If Mr. Puente Garcia was still receiving medical treatment away from the TDC facility that received the notice of hearing, when it was served and subsequently post-hearing, in other words, he was never back in time to make some representation to that court that, hey, I can't appear, then the court is gonna, makes a lot of sense why you have a motion to dismiss filed. I'm gonna give the state an opportunity to see if they can get those records and supplement the court with any of that information. So I will see you all on the 28th.
Thank you, Your Honor.
Thank you very much. Appreciate your work.
Have a good day, everyone.
You too.
Excuse, Your Honor.
Yes, sir.
Thank you, ma'am.
Can we